and welcome back to the Immigration Ain't Easy podcast. This is a special episode of the Immigration Ain't Easy podcast. You can find the podcast at immigrationainteasy.com, and it's available on pretty much any major podcasting app. This episode of Immigration Ain't Easy is special because we're doing it for the holidays, and primarily the holiday of Festivus. But before I begin, I'd be remiss in wishing all of you a happy Christmas, Kwanzaa, Boxing Day, Hanukkah, New Year's, whatever floats your boat. Enjoy that holiday that's coming up, or holidays. So today's episode is the first annual Immigration Condemnation Awards. Condemnation, not condoms, but condemnation. And we are going to share stories today. Today is December 23rd. We're going to share stories on Festivus. For those who are not aware of what Festivus is, it was invented by an author and editor, Daniel O'Keefe, and then his son, Dan O'Keefe, who was a writer for Seinfeld, wound up popularizing it through the show on the 1997 episode called The Strike. In that Seinfeld episode, Frank Costanza, who is the father of George Costanza, who was played by the late Jerry Stiller, a Festivus for the rest of us. And Festivus celebrations kick off with an airing of grievances. And when you're an immigration lawyer, there are a lot of grievances that can be shared. Our clients can share a lot of grievances. There are a lot of stories that can be shared. And that's why I feel like this is an apropos day to air these grievances. That the U.S. government has disappointed us immigration lawyers and our clients over this past year, 2024. So this is our Festivus. Observations and complaints about the U.S. immigration system in 2024. This is not a complete list of complaints. There are many more. But one thing I wanted to point out to those who are listening, when you send immigration applications to the U.S. Citizenship and Immigration Service, right now they're taking 1 to 2 months to send receipts or even deposit the filing fees. Think about that. 1 to 2 months to deposit the fees that people are paying to the U.S. government. Totally unacceptable. We started to see an uptick of this back in April when the U.S. government ironically raised all the filing fees April 1st, and then all the chaos occurred. The different locations for filing were provided for, and it just seemed like the mailroom couldn't catch up with all the filings that probably came through prior to the April 1st date. And it's just continued to go on and on. And again, this is just to get a receipt notice from the U.S. Immigration Service. 1 to 2 months. Rejections. This has been a long-standing problem, and it costs our government and our clients, and sometimes the law offices, a considerable amount of money. We see rejections of applications quite often, unfortunately, for ridiculous reasons. Back when Trump was president, applications would be rejected if they didn't put NA or not applicable in certain fields, or in fields that weren't filled in. And that had never been an issue before. Usually, if you leave it blank, oh well, you left it blank. But the U.S. government just seems to get its kicks off of rejecting applications. And it's to the tune of sometimes 40 to 50 or more dollars for the package of the entire application being returned to either the lawyer or the individual, or the company. Give you an example of one that just happened to us in the last week. I have a client who has applied for what's called deferred action. And deferred action is kind of like, it is like DACA, but there's a different route to filing for deferred action, which allows a person to stay here. And I filed 2 applications, one for a wife and one for her husband. And they were the exact same applications. Each of them had separate forms. They were filed together because it made sense to file them together. And the husband wrote a statement, which is required, a signed statement explaining why they should be provided deferred action, which would allow them to remain in the U.S. for a certain length of time and to be able to get a work permit as well. And they've already gotten deferred action. However, a year ago, the government changed where you have to file the deferred action request. And there's now a form called a G325, A, I think it is, but I can't remember what letter designation. But there's a form that they're using for this. And when I submitted both applications, I figured the letter from the husband for both of them should be sufficient. Well, I got a receipt notice from the U.S. government about a month after I filed it, and the receipt notice was for the husband. It didn't have a receipt number for some reason, so there's really no way to track the application. But I couldn't figure out why I hadn't gotten a receipt for the wife. And then all of a sudden in the last week, I got a returned packet, which only included the wife's form and several documents that looked like copies of documents I had already submitted, with a letter saying that they needed a signed statement from her as well. And not only that, but the U.S. Immigration Service, which last I checked works for the U.S. government, FedExed it to me. And my assumption is that FedEx at least cost them $30 to $40, if not more. Instead of just accepting the application and then maybe informing me after the fact that they need the letter, they just sent the whole damn thing back. So there you go. Rejections. What a fucking joke. Unacceptable. And what a waste of money on top of it. The amount of money that's wasted by this government. I mean, Elon, do your thing. You want to, try to stop government waste? Well, here's one way to do it. I bet you won't, though. How about this? Stop denying TN visas. I mean, what the fuck is going on at the State Department? The consulates just seem to be denying TN visas right and left. I mean, you're an engineer? Nope, denied. You're a scientific technician? Nope, denied. You're a lawyer? Nope, denied. It's insane what's going on. And it's completely contrary to the idea that we should be legally permitting people into this country. Because if you're not going to give them legal visas to come and work here, just think about what alternatives people are going to use to get here. The U.S. State Department, shame on you. Unacceptable. Now, let me tell you something else that's insane. The State Department's websites. The consular Electronic Application Center, CEAC, and the US travel docs. If you want to use them, good luck. It might work, it might not work. I mean, it is 2024. I mean, you would think that technology is well beyond the problems that we see on these websites. It kicks you off. It won't let you log in. It constantly gives you difficulty when you're trying to upload documents. It's absolutely appalling. My only suggestion is maybe hire some foreign workers to do your engineering over there. It's the best with US travel docs. I kept getting this message over and over again, and then I started having nightmares about it. We're sorry, but something went wrong. Please try again. And if this persists, contact the website administrator. Well, how the hell am I going to find the website administrator? I love it. It's absolutely insane. And then they tell you that they've been notified of the issue and they'll take a look at it shortly. Thank you for your patience. I would figure shortly means 2030 if you're lucky. All right, so it's time to get to some of the most ridiculous stories I've received from colleagues during the past year. And I want to, first off, just note that these are stories that were shared to me by other lawyers. The information provided is based off of what they told me. I can't confirm or deny that this happened, but I can say that, with pretty good, pretty good authority that these individuals are not going to make these stories up. And they do seem pretty much what you would expect from the government, except one that really shocked me, and I'm actually still shocked that it happened, but we'll get to that. That'll be the last one. I'll save that for you. Let me just start off with my own personal experience, and I've shared this with a lot of folks, but it has to be restated because it's absolutely the most ridiculous thing I've seen in the 24 years I've been practicing immigration law. So, like I said, U.S. government's taken a while to deposit checks and credit card information for filings. A lot of times those credit cards end up not getting through, and then they reject the whole application, and it's just a total shit show. This story is, quite opposite of that. This is a situation where the government took money that they should have never taken. So here's how it went down. My client's a religious organization, and they had filed for what's called a religious worker, R1, change of status for an individual who's in the U.S. at that time on a tourist visa, it's called a B2 visa. And they had filed it on their own, and it ended up in the Texas Service Center in the premium processing unit. And the premium processing unit sent a request for more evidence, asking for proof that they could support or pay their soon-to-be or hopeful employee as a religious worker. So the petitioner, the organization, sent financial documentation evidencing that they have enough money in their account. But they also figured they would send a copy of a dummy check, not an actual check that they've paid the individual, but they made the check out to the individual with dates on it, just kind of saying, look, here's a sample check. And they even wrote clearly on the top of the check, sample. And the check was made out to the individual that they were sponsoring for the amount of $1,500. Again, it's a sample. They didn't send the actual check. In the response, they just sent a copy of that check. So in August, this was back in July this summer, in August, the organization gets what's called a notice of intent to deny, a NOID, which stated that they presumed that the individual was getting paid and that he was already working, which he wasn't supposed to be doing, based off of what the check said. And so that's when the organization came to me, and we strategized a response, and we provided a sworn statement from the individual himself that he had not been working or employed for the time that the government thought he was, and also a sworn statement from the president of the organization stating the same. And then I figured the best evidence would be to send the actual check to show that it was never deposited or cashed. So I wrote pretty prominently on the check, void. When you see void written on a check, you pretty much know that check's void. And then I put the check in a sandwich bag, attached it as an exhibit, and then my cover letter clearly stated that it was only to be an exhibit and to be shredded by them after they looked at it. And mind you, again, the check was made out to the individual, and it also said sample on the top. So I sent it back as an exhibit, and 5 days after the government received it, I was contacted by the organization. Guess what? U.S. Immigration Service deposited the check. They deposited a check made out to somebody, not to the U.S. Department of Homeland Security, a check that had sample written on it, that had void written on it, for an amount that doesn't really equate to anything else that would have been filed, because usually you have to file a filing fee or money to the government with a form that corresponds to it. And not only did they deposit it, but the bank accepted the check. So my client, their account was debited $1,500. I emailed the premium processing unit. I emailed a couple of other places, was getting no response. Literally 2 weeks go by, and finally I get a response from the premium processing unit, and I've got it here. This is so great. I got this on September 9th. So we're talking, gosh, when did I first email them? I first emailed them, late August. And it says, thank you for contacting the Texas Service Center Premium Processing Mailbox. A refund request for the $1,500 has been forwarded to the Financial Operations Center for further processing. You should receive your refund within 60 days. And that's it. No apology, nothing. And I still wonder how the hell that check ended up getting deposited. Meanwhile, they approved the petition, but then they didn't grant this poor guy his change of status because they still felt that he had been working in the United States unlawfully and he had to leave. So that is my ridiculous story of the year. Again, unacceptable. That should never happen. I received this one. This was pretty funny from one of my colleagues in Miami. I filed an I-539, which was for an extension of a person's visa status for the wife and the 6-year-old child of an O1 visa holder. So that would be an O3 visa. U.S. Citizenship and Immigration Service, which is where it's submitted, sent a request for evidence asking for pay stubs for the 6-year-old to prove that he worked legally in the U.S. while on O status, which, by the way, a 6-year-old's not legally allowed to work, and a person on O3 status is not allowed to work. The lawyer replied that the child was in first grade, and it was illegal in the U.S. for 6-year-olds to work. U.S. immigration approved the petition after that. Unacceptable. It really harkened back to the one time I got a request for evidence once on a marriage case, and the marriage-based case request had asked for evidence of a bona fide relationship between my client and Maurice Goldman, the attorney. That was fun to respond to. I was like, I don't think I can show bona fides of my relationship with my client except for, our fee agreement, which I'm not sharing with you. Another story from the same lawyer in Miami. So there was an I-140 filed, and this is a petition for a worker, a foreign worker. So the I-140 was filed for a LLC with over 3,000 employees. And they don't have tax returns as they're a pass-through entity owned by a U.S. company listed on the New York Stock Exchange. So when you do an I-140 petition for a worker or an employee, you have to show ability to pay. And there's different ways to show ability to pay depending on the company size, depending on the evidence. And the ability to pay is how much can the employer pay this individual once they get the green card? And is it higher than or at the level of what they're supposed to pay the person based off of the prevailing wage or the actual wage? And in this case, for ability to pay, she supplied the SEC's 10K forms, a letter from the CFO, and the individual employee's W-2, since that individual was working in the United States already on a temporary work visa. And the W-2 showed $358,000 in wages, so highly remunerated employee. U.S. Immigration then sends a request for evidence asking for more documentation, and they state that the W-2 showed only $73,858 in salary, which is not the case. It was $358,000 in wages. And they could have just used the SEC 10K forms, a letter from the CFO. They didn't need to use that. But they were saying that because the W-2 showed only $73,858 in salary, they did not have the ability to pay because it was lower than the proffered wage. And they didn't mention the two other documents, the 10K and the letter. Well, guess what? The $73,858 was in fact the amount listed on the W-2 as federal income tax withheld on reported wages of $358,776. So the lawyer tells me that she replied with a screenshot enlarging the W-2 with arrows indicating box 1 for wages and box 2 for tax withheld. And that one was swiftly approved after that. Thankfully, both of those were approved. The one with the child labor, and the misunderstanding of taxes as income. Again, unacceptable. I mean, this is not rocket science. It should be pretty understandable. All right, so now we've got a story that involves Emma. Now, who is Emma? Let me read to you who Emma is. I had to do a little bit of a deep dive on who Emma is because I wasn't quite sure how you explain it, but Emma is the virtual assistant for the U.S. Citizenship and Immigration Services. It's a computer-generated virtual assistant who can answer your questions and even take you to the right spot on the website. Emma is named for Emma Lazarus, who wrote the poem inscribed at the base of the Statue of Liberty about helping immigrants. Inspired by her namesake, and this is on the USCIS website, inspired by her namesake, our Emma can help you find the immigration information you need. Or can she? So that's Emma. And that takes me to this story. So this lawyer says she used to use Emma quite often, and it allowed her to get past, trying to call the dreaded 1-800 phone number, which you have to traditionally call to get answers on issues related to cases from the USCIS. So when this day she finally got through to Emma, because sometimes you got to wait for Emma, and Emma is first a virtual assistant, but it can lead into a human. And so when she got through, she responded with the first name, last name, date of birth, and mailing address with her client's information. Because why would Emma even want to know the date of birth of the lawyer? And it doesn't even apply to why the lawyer is inquiring. And then in this case, and in all cases, this lawyer would make it very clear that this was for a client and that she was an attorney of record. And she sent me a screenshot of what happened on this fateful day. It's actually quite humorous. She said, I'm the attorney of record with my G-28 on file, which is the notice of appearance. She gave her phone number. She gave her email. And the response from the live chat operator that was on with her said, you provided the above information as if you were the applicant. When asked to provide your first and last name, you provided the client's. Well, of course she did. And then the next thing the live agent writes is, I cannot continue this chat. Thank you for contacting USCIS. Enjoy the rest of your day. And this is the sort of bullshit we have to deal with. It's so stupid. But that one kind of made me chuckle. This other story, the same lawyer sent me, had entered her appearance on a case. This was with the court, with the immigration court. And there was a quickly approaching what's called master calendar, which is an initial hearing with the immigration court. And she requested a copy of the what's called notice to appear, which is a charging document that the government, DHS, Department of Homeland Security, issues to somebody when they're put in front of an immigration court into what's called removal proceedings. And she had asked for a copy of the notice to appear from an ICE attorney since she couldn't access an electronic copy through the court information system. And generally, the ICE attorneys are pretty easy about giving those over, and it's usually not a problem. But in this case, the attorney wrote her back, and she said he must be a member of Zoolander's male model crew because they responded, we do not have a copy of the NTA that we can send you. And she thought maybe they had lost the NTA. Like, how is that possible? It should be in their system. And so she responded to them, and they replied, our copy is saved to the computer. I can't send you my computer to send you a copy. Literally, I just read it. She screenshotted this to me to maybe avoid embarrassing the office that this came from. I won't note it, but holy crap. I mean, you can't send something because it's saved on your computer and they can't send you the actual computer. We know that. It's amazing. I mean, what we see in immigration is mind-boggling. All right. I'm going to take a sip of water, and then we'll get to the last few. All right. And by the way, anyone that sent a story gets a T-shirt courtesy of Immigration Ain't Easy. The shirt says resist, fight, endure, RFE, in honor of requests for evidence. And maybe I'll start up a little merch stand on the website. All right, so now we've got this story. In October 2019, her client was sponsored by the employer, and this was in what's called Employee A. And this does go back a bit, but we'll still tell the story because it's worth telling. She was sponsored, the Employee A was sponsored by an employer for what's called an EB-3 green card application. It's basically employment-based immigration. The visa bulletin, this chart that the government uses to decide when a person is eligible for what's called adjustment of status, or when they are eligible based off of this chart, was current at that time. So they filed what's called the I-140. Again, that's the petition for the foreign worker, and the adjustment of status, the green card application, at the same time concurrently. And they also had the same issue with another coworker who is Employee B. And they submitted a separate application in a separate filing, same employer, two separate employees with the same types of applications. So after a delay, they were issued 2 receipts total for both employees. Usually you're going to get at least 4, one for the I-140 petition, one for the I-485 for Employee A and Employee B. In this case, Employee A only received an I-485 receipt, and Employee B only received an I-140 receipt. And the receipt numbers were sequential, as if it was one case instead of 2. So after confirming that USCIS did cash checks for both employees, they started inquiries with the USCIS and asked for supervisory review requests. They were using congressional for inquiries to try to clear it up. And USCIS asked that she mail in copies of the packets and supporting documents, which they did. They also did Freedom of Information Act requests for both employees and the company, which showed that the case had been combined somehow and that no I-140 receipt was issued. The results for the labor certification in the form for employee somehow ended up under the Employee B's information. Then this just gets insane. Employee A gets a request, again, RFE, request for evidence, for proof of a pending I-140. So they provide the FOIA, inquiry records, and the payment confirmation in response to the RFE, and in person during the interview. But the adjustment of status was denied, saying no I-140 receipt existed. So they filed a motion to reconsider, an I-290B, and that was denied, saying no I-140 receipt existed. The lawyer then had to file a federal mandamus suit, a lawsuit, in June of 2024, and that's what brings us all the way up to this year. So this is like 5 years in the making. And finally, USCIS issued the I-140 receipt. They approved the I-140, reopened the I-485 in July 2024, and this Employee A is still waiting on a decision on his adjustment of status, his green card application, despite the original denial saying the only issue was the missing I-140 receipt. Unacceptable. This is absolutely unacceptable. to have to go to this extent because of a bureaucratic gaffe. All right, got a few more for you. This one's an interesting one. This guy has a 94-year-old client. Congratulations on living that long. Who married a U.S. service member way back when. They have 4 kids born in the U.S., had a green card, and then the husband passes away. Kids are grown, so this woman goes back home. And what happens, and this does happen, I've seen on a semi-regular basis, eventually the kids want her back in the United States because she's 94 years old and they want to spend time with her, and she's got dementia. And, who doesn't want their parent with them, especially late in their life? But again, her green card was basically lapsed because she left the United States. So now the children have to do a new petition for the mom. That's the easy solution. So they submitted, it's called an I-130 petition. They document everything, her previous history as a permanent resident in the U.S., her marriage to a U.S. service member, the children, the whole 9 yards. USCIS sends a receipt showing her date of birth as having been born in the year 2035. Okay, so she's a time traveler. Instead of her actual birth year, which was 1935. So the lawyer calls immigration to the dreaded 800 phone line, and the representative on the phone says, "Sir, it is your burden to prove that she was not in fact born in 2035. Again, I repeat, quote, "Sir, it is your burden to prove that she was not in fact born in 2035. So the lawyer asks if he should submit a newspaper with today's date on it or a 2024 calendar to him as quote-unquote evidence. And the lawyer also told him that he should be excited because he gets to go to the president and say he's discovered a time traveler from the future. Thank you for sharing that story. That is, again, absurd. I mean, you got to throw away common sense when you're dealing with immigration in many instances. And I will say there are, to their credit, some really good people there. But boy, oh boy, this is just beyond the pale. All right. So now this story. So back in April, this takes us back to April of 2024. There were new forms. They changed around some of the filing fees. They added this new asylum fee. And so, it got a little confusing. We had to try to work our way through it. And some of the forms were a little bit hard to understand. And this lawyer was filling out the I-140 petition. Again, it's the petition for a foreign worker, but it was for a self-petitioner. And it makes no sense. If you're doing a self-petition as one of the categories is called extraordinary ability. If you're doing an extraordinary ability self-petition, you have no employees, but there is a box on the form that asks how many employees that self-petitioner has and whether it's 25 or less or over 26 or more, because there's this asylum fee that has to be paid, which is either $300 or $600. But when you're doing a self-petition, you figure there's no employees, so it's got to be under 25. So I think at first a lot of lawyers were looking at that thinking, do we mark that off? What do we do? So this guy filed it. He filed it for this high-level scientist. The case was rejected. and the USCIS was supposed to send the whole packet back because that's what they do. I just told you, they waste a lot of money on this. But then he said something went spectacularly wrong. Instead of the 1,600-page application, he got back their cover page, the checks, a U.S. Postal Service note saying the case was lost, and a 2024 retail Christmas catalog in July. Christmas catalog in July. He doesn't know if the lockbox where it went was trolling him or if the U.S. Postal Service thought, close enough. So he had to then call his client. He says, cue the awkward client call. I didn't get your case back, but I did get this festive holiday catalog. Oh, and maybe put a freeze on your social security number just in case your personal info went on its own adventure. He says that his client was an absolute legend, understood, and was joking about it. And he thinks that the client kept the catalog as a souvenir along with his eventual approval notice, which he finally got. But man, this Christmas catalog is going to haunt this lawyer forever. And he said that himself. So ridiculous story, happy ending. And it also goes to show if you're doing immigration law and you're a lawyer, you really have to, you just have to roll with the punches sometimes and just, deal with some nonsense and have to try to explain that to your clients. All right. So I have a story, and this story, I'll save this last story. I have two more, but it's amazing. So in this next one, the U.S. Immigration Service issued a notice of intent to deny. They didn't even send a request for evidence. Usually they'll send a request for evidence first. And as I said earlier, like with that return, that situation where they deposited the check when they shouldn't have, they sent a request for evidence and then a notice of intent to deny. In this case, they just sent the notice of intent to deny. And it was for an EB-5, which is for a investor-based green card. And the notice of intent to deny contained a copy-paste of the entire index of exhibits submitted with the case. That has to be, dozens and dozens of exhibits. And it listed every single document submitted and acknowledged that the applicant petitioner submitted those documents. Then the notice of intent to deny requested exactly the same documents listed with the remark, quote, unless already submitted. The conclusion to the notice of intent to deny claimed that the source of funds cannot be verified. Again, it's investment-based, so you have to show where the funds came from, unless the petitioner provides tax declarations of the petitioner's husband. Now, mind you, the petitioner is married to a woman, and their marriage certificate and the wife's documents were submitted. And they also wanted a HOCUS, HOKKUS. So the lawyer had to Google search what HOCUS is, and these are Chinese household income certificates. And by the way, the client is not Chinese and has never even been to China. She said, the lawyer, this is only the beginning of the story. So they responded to the notice of intent to deny, identifying each requested document and explaining factual inability to comply with husband and HOCUS requests. Immediately upon submission, the U.S. Citizenship and Immigration Service issued a notice titled, quote, affirmation of approval, end quote. The notice literally said, quote, on July 12th, 2024, we affirmed the previous approval of your case. The case has been returned to the Department of State for visa processing, end quote. Would that be a happy ending? No, not so fast. The National Visa Center, which is the State Department, refused to issue visa bills because apparently there was no approval for the case on the U.S. immigration side. U.S. Citizenship and Immigration Service refused to forward the case to the National Visa Center because they claim that the case is under the jurisdiction of the Department of State. Attempts to engage with the Ombudsman's office failed because USCIS responded to the Ombudsman request, quote, "The affirmation of approval notice was issued in error and should be disregarded," end quote. And since USCIS responded to the inquiry, the Ombudsman closed the case. So there we are. And so far in 6 months, this lawyer has made 16 unsuccessful attempts to figure out where the case is and what is the actual status of the proceeding. And this is absolutely ridiculous. Again, people just wanting to legally come to the United States. All right, here we go. This is the winner. And this story, I'm not sure whether a complaint was filed. If not, I highly recommend filing a complaint. I don't know if there's a recording of what happened here, but this is it. This is the peak of the most disgusting, embarrassing, pathetic act that I've heard of by a government employee in 2024. And here it goes. My client, who is a Colombian, appeared for her naturalization interview, her citizenship interview, in Phoenix. The officer began with the standard questions and then dramatically veered off course. He asked her a bunch of invasive questions that had no bearing on her application, including whether she had a boyfriend, if she liked having sex, if she wanted children, and if she would like to get married. Then he asked her out on a date. She said she wasn't interested, and he said, and I quote, or the lawyer who sent this to me quoted, this was his response: "Oh, you must be a lesbian." Unfucking believable. This man was in a position of power. He could have denied, delayed, or lost her naturalization application. And she stuck to her guns. I mean, good on the applicant, and she became a U.S. citizen. But holy crap. I mean, this is really something that needs to be investigated if it was not already done. And this officer should probably be relinquished of his duties. I had just messaged the lawyer, but she's not around. I'm not going to say who it is, but I'll follow up and let you know if she filed a complaint or what, I mean, you would think there's a recording of it somewhere. So anyways, that is our winner or loser. No matter how you look at it, I think a lot of these are kind of losers in different ways. I did get one other person who made a good point. I mean, the most illogical thing that happened in 2024 were voters. I mean, who are these people who are U.S. citizens that voted for somebody who is going to deport their family members and or friends? I mean, it's absolutely appalling. Humanity needs a check. I mean, we need to really check ourselves. Where have our morals gone? Whatever happened to the idea that we care for one another, and that we actually, want to help others, get up off the ground and build, and the idea that our country is built on immigrants and that drive to achieve and to have economic success, and protection. And it's just, it's sad. It's a sad state of affairs. So I hope that you all have a wonderful holiday week ahead. I hope you enjoyed our Festivus episode of Immigration Ain't Easy. Thank you to Emma Goldman for all the hard work you've done in this last several months since I got this podcast going. We are now on episode 20, and I don't see any end in sight. If you have stories you want to share in the coming year, or if you're interested in being interviewed, I'm more than happy to talk to you and potentially have you on as a guest. We need to keep sharing these immigrant stories. We need to make sure that hypocrisy has been exposed, and that people who are taking advantage of immigrants cannot be doing so. And unfortunately, that has been the case from many who support the Trump agenda. So, let's just keep up the good fight. And I look forward to sharing more stories after the new year. So thank you all. Happy New Year, happy holidays, and happy Festivus, most importantly.